Mr Chair.
Very much, Mr Chairman, and I'm happy to take a call on this bill and perhaps pick up where my colleague Louisa Wall just left off, and that is the difference between a public housing development and a private housing development, which is something that seems to have escaped most of the members opposite. That using compulsorily acquired land for a public purpose, which can include a public state housing development, is quite different to using compulsorily acquired land for a private development, including a private housing development. And that is the distinction which seems to be lost on the members opposite, but yet that is the exact distinction that this bill is seeking to address. Because if land that was compulsorily acquired for one public purpose, such as a school or, in many cases around the country, Defence Force, because it's a lot of surplus Defence Force land, such as Hobsonville, is being used for housing developments. If that is being used for government-led housing developments, i.e. state housing-led housing developments, there is no legal issue now, because the law already allows for that. But where the ambiguity arises is where the government wants to dispose of that land for the purposes of housing development, but not housing development that they are going to do. And that is the important distinction which many members opposite don't seem willing to even acknowledge, and certainly the Minister doesn't seem willing to address or explain. It's because if it is about state housing development, that is already allowed for. If it is about state housing development that is then subsequently sold, as has happened all over the country, where originally you take my electorate, the Hutt Valley, most of that area, big chunks of most of that area were state housing developments that have over time been progressively sold off bit by bit here and there, people potting the private sales around, and as a result that's been absolutely fine. Nothing in the law stops that from happening now. But where the ambiguity arises is if the government has a block of land that they have compulsorily acquired that they don't want anymore, that they would otherwise be obliged to offer back to the original owners under the Public Works Act, and they decide that they want to ensure it goes for a housing development rather than some other purpose that the original owner may have. Rather than dealing with that issue, what they are trying to now do is allow the Public Works Act provisions to continue to apply when they then sell that land to a private developer. And that is a massive infringement upon private property rights. I never ever thought I would see the day when the Green Party is united with the Labor Party in defending private property rights, and New Zealand First as well, and the ACT Party are the party arguing against it. I never thought I would see the day in the House, but apparently according to David Seymour, that trading away your principles like that is called being constructive. And when trading away one's principles, that's actually okay, providing there's a 10-year sunset clause. It doesn't matter. Principles are allowed to be breached retrospectively as well, and that's a whole new thing. That's a whole new distinction which I think the House is very excited about, because I certainly didn't understand that principles were available to be traded off retrospectively in the way that David Seymour has suggested they are. But I want to highlight in the minute that's right. He's at a caucus meeting right now. But as the Minister mentioned, in his contribution, when he tried to address this issue at the very beginning, he talked about building by the Crown. Those were the words that he used when he was talking about the provisions in the Housing Act. Those were the exact words, building by the Crown. Nothing in the existing law stops that happening now, and nothing stops the building that has been done by the Crown subsequently being sold. Where there is ambiguity is where it is a private developer. Take Pomari, for example. Now, I don't know the basis upon which the Pomari land was acquired, but up until recently, it was all state housing. So had it been acquired under the Public Works Act and it was all state housing, that would have been fine. What the government have done is they demolished all of the state housing that was in that area. So it became vacant land. And they then sold that vacant land to a developer. So it is no longer a government-led housing development, in the words of Nick Smith, building by the Crown. That's not building by the Crown. The original houses were building by the Crown, but they were all demolished. So when the Crown disposed of that land, it was empty land, it was vacant land, and it was sold to a developer for private property development. So therefore, should that have been offered back, if it had been compulsorily acquired, should it have been offered back? And I haven't heard an answer from the government about that. And I want to hear an answer from the government about that, because that is what this whole issue turns on. And in the absence of any proper legal explanation for the need to do this by the government, why are we supporting it?
Megan Woods.
Thank you, Mr.
Dr.
Chairman.
Megan Woods, sorry.